A. Entered into a contract of sale conveying a house and lot in favor of B. Unwilling to pay thousands of pesos for notarization fees, A and B decided not to have the contract of sale notarized. B nonetheless made C, her nephew, a second-year law student, check the contract. C informed his aunt that the sale was void because it was not in a public instrument. He thus advised her to file a case in court to declare the contract of sale void. Is C correct? Reasons. C's advice is incorrect. In estate of Pedro C. Gonzalez versus heirs of Marcos Perez, GR number 169681, November 5, 2009. Citing the established principle that the absence of a public document, as required by Article 1358 of the Civil Code, does not invalidate the contract between the parties, the court said, an unnotarized sale of an immovable property is valid between the parties. The form requirement is for convenience and registration purposes, not for the contract's basic validity. The sale of the house and lot, even if not notarized, remains valid between A and B because the Civil Code does not require notarization as a condition for validity. What is affected is enforceability. A. It cannot prejudice third parties unless in a public instrument and duly registered, and B. Proof in court may be limited because an unnotarized contract is merely a private document that must be authenticated before admission as evidence. Thus, C is incorrect in stating that the contract is void. At most, she could seek notarization later or compel A under Art. 1357 to execute the proper form.